Henry Bracken from the Netherlands. I've been collaborating with him for a long time. He's a professor in Groningen at the Faculty of Law, and he's also at the CS department, Computer Science Department, Intelligent Systems at Utrecht University. He's a leading figure in two communities, the artificial intelligence and law community and the computational modeling of argument community. And his status goes back already to his dissertation from the early 90s, I think, entitled Logical Tools for Modeling Legal Argument. He has built models and provided thoughts about case-based reasoning, rule-based reasoning, and recently also has been investing a lot in evidential reasoning. I'm curious what he will have to say today. Henry.
So somebody of you removed my talk from the desktop. Kun je me even helpen, want ik heb mijn bril niet op.
Moet ik het even doen? Ja.
Desktop, anders vergeet ik hem. Stanford ver. Gaat het zo?
Ja, maar dat doe ik.
Open, ja. Mag ook.
Oh, it is on there. It was already on there.
So thank you, Bart and Marcelo, for inviting me to this conference. My main research interest is in theories of rational legal proof, especially in criminal cases. In this talk, I will also talk about the cognitive plausibility of various models of rational legal proof. Because I think even if you can come up with a wonderful theory of rational thinking about legal evidence, if it's cannot be attained to in practice by the fact finders, then it is not of much use. Having said so, I have to make a disclaimer. I'm not a cognitive scientist, so I have no empirical data to offer you, unlike Bill Thompson in the previous talk, which was extremely interesting to me. Just some speculations and some suggestions for future research. Well, you all know that if you want to prove the facts in criminal cases, then full certainty is not achievable. For very many reasons, eyewitnesses can be unreliable, expert witnesses sometimes or even often disagree, documents can be manipulated, generalizations about how the world usually is, very often used in legal proof, but they can have exceptions. Even DNA tests can have, random match probabilities, and even confessions might be false. There are many cases, known cases of false confessions. In the Netherlands, there's even one murder case where 12 different people confessed to a murder, and none of them was actually the killer. So, if you want to build a theory of rational legal proof, then it's quickly clear that logical deduction will not bring you very far. And I reached that conclusion even though I was trained in logic, in formal logic. If you look at the literature, you broadly see three approaches here. First of all, of course, Bayesian approaches. The standard Bayesian approach would be determine prior probabilities of the various hypotheses of interest, determine how likely the evidence is under the various hypotheses and then calculate the posterior probabilities of the hypotheses given Bayes' theorem. There are more sophisticated versions of this with Bayesian networks, but I will not really talk about them. Mathematically well-founded, but as is well known and also mentioned today, people often have problems in thinking in Bayesian ways. Moreover, in many legal cases, you won't have numbers, or at least it will be hard to find reliable numbers that you need as input to Bayesian thinking. So people have studied alternatives. One alternative is story-based models, taking a narrative approach where the fact finder has to construct alternative stories or scenarios about what might have happened, and then they have to choose the best scenario, the one that is internally the most coherent and that offers the best explanation of the evidence. This approach, I think, goes back to a number of psychologists in the US, like Bennett and Feldman, Pennington and Hastie. They originally only had an empirical aim, just to describe how fact finders think about evidence in legal context, but other people have turned this into something normative. They said this is really how people have to think, fact finders have to think about evidence. A third approach about which I have done most of my research, is an argumentation-based approach, probably going back to the famous American scholar John Henry Wigmore, where you construct arguments for and against the charge, starting with the available evidence, and then determine which arguments survive the competition between the conflicting arguments. As I said, maybe going back to John Henry Wigmore, and this was modernized in the 1980s and 1990s by some new evidence scholars like William Twining and others. And also in AI and law, the field of Bart Verhey and myself, people have applied this approach in a more formal way using the logical models of argumentation as they have been developed in artificial intelligence. And there are also combinations. For instance, our former PhD student Floris Bex studied the combination of story-based and argumentation-based models. And currently, two of our new PhD students are investigating, well, Charlotte Vleck in Groningen is investigating how alternative stories or scenarios can be represented in Bayesian networks. And Sjoerd Timmer, who's present here in Utrecht, is investigating how argumentation can be used to give more insight into what Bayesian networks tell about a case. I should say that even though I've mostly worked on the argumentation approach myself, I don't have very firm opinions about what is the best approach. I think all approaches have some use. There may be cases where Bayesian thinking is better, maybe cases where argumentation-based thinking is more useful, and there may be cases where you have to combine various ways of thinking. So I'm not so strongly opinionated as some people here in this room are. What I want to talk about today is one way to contrast these three approaches, which contrasts Bayesian thinking and story-based thinking on the one hand with the usual way in which the argumentation approach is applied on the other, which is and I make a distinction here between what people have called direct versus indirect probabilistic reasoning. Some people might call this deduction and abduction, but that's not quite the same. In argumentation, you usually reason from the available evidence, the testimonies, the trace evidence, the documents, and so on, and you try to draw conclusions from them by applying, for instance, generalizations. Generalizations are very often very important in this approach. William Twining has called them the glue that holds the evidential arguments together. But the other two approaches reason in a more indirect way. They form certain hypotheses about the case, and then reason from these hypotheses to the evidence. In these approaches, you have to estimate how likely the evidence is under these various hypotheses. Of course, they don't stop there. Then they make the turn back to the hypotheses to see what is the hypothesis that you can accept in the case. And I now want to illustrate these two different ways of thinking by a simple example, and I will model this simple example in the three different approaches. I should apologize from now that the example is really simplistic. I just made it up to illustrate the three approaches and the two ways of probabilistic thinking. Please don't read too much in these examples. So first, the argumentation approach. Suppose you have evidence that John's DNA matches with DNA found with a victim of a rape case, then you can presumptively conclude that John is the rapist. I said it's simplistic, but please bear with me. This is an argument. It can be counter-arguments. For instance, you have a witness, Mary, who said John was elsewhere at the time of the rape. From that, you can presumptively conclude that John was elsewhere, and then you can, from that, deductively conclude that he cannot have been the rapist. This is a counter-argument, two arguments with contradictory conclusions, and what then argumentation-based models, one thing they allow you is to think about the relative strength of these arguments. Maybe you accept the argument based on the witness testimony, maybe the other way around, or maybe you cannot tell which argument is the stronger, and then you cannot draw any conclusion. This is not all that argumentation-based approaches amount to, because sometimes you can defend your argument not by saying it is stronger than your counter-argument to my argument, but you can counterattack the attacker. For instance, if you have evidence that Mary is actually John's girlfriend, you might be able to build an argument that Mary has reason to lie because she wants to protect her boyfriend, therefore she cannot be believed, which then undercuts the argument from Mary's testimony to the conclusion that John was elsewhere. And that would then defend the initial argument that John is the rapist against the counter-argument. So these are the kinds of interactions between arguments and counter-arguments that argumentation logics are meant to formalize. And the other point that this example illustrates is that really all arguments are built starting from evidence, from DNA match, from a witness testimony, and, well, some unspecified evidence that Mary is John's girlfriend. Then the story-based approach. That works completely differently. Here you have two pieces of evidence, the same two pieces of evidence from which I constructed these arguments. But now you try to find explanations of these pieces of evidence. For instance, well, John had a certain motive to rape the victim, then that made him rape the victim, and that explains why his DNA matches with the DNA found in the victim's body. And Mary's testimony can be explained by saying, well, Mary is John's girlfriend, and therefore she wants to protect John. And then you have to ask questions like, well, does the story explain the evidence? Well, here that's the case. Is the story in itself plausible and coherent? For instance, does it instantiate some plausible story scheme, maybe some kind of intentional action scheme? And is it anchored in common sense knowledge? Are the relations, the arrows here, based on plausible common sense generalizations, maybe? But that's not all. Of course, you can always find another story, an alternative story that explains the evidence. For instance, someone else with the same DNA profile actually raped the victim. That can also explain the match of John's DNA with the victim. And that Mary's testimony can be explained by saying, well, it's actually true what she says. So that explains that she said that John was elsewhere, namely, John was elsewhere. So you already see that the reasoning is the other way around. Here you reason from the hypotheses to the evidence to see how how the various hypotheses explain the evidence. Well, then you can compare the alternative stories, for instance, under which story is the evidence the most likely, and then you have to make a choice in this approach. Then the Bayesian approach. Here is Bayes' theorem in two forms, a simple one and a more complicated one, with the denominator made more explicit. If you know Bayes' theorem, I don't have to explain it to you, and if you don't know it, I have no time to explain it to you. So all you need to know here, if you don't understand it, is that the expression in the blue box is the conditional probability that some hypothesis is true given the evidence that you have. And you can compute that if you know all these probabilities on the right-hand side. And here, to show you that this is really also indirect probabilistic thinking, if you look at the bottom at the things that I've made red, one thing you have to estimate is the conditional probability of the evidence given your hypothesis. And another thing is the conditional probability of the evidence given the negation of the hypothesis. So here, fact finders, for instance, or experts, really have to think about how the evidence can be explained by the various hypotheses. So the reasoning is from the hypotheses to the evidence. Of course, the Bayesian approach, fact finders also have to estimate the prior probability of the hypothesis, which is a notoriously hard problem, but that is not really the topic of my talk. And then, well, a Bayesian analysis of my simple case could go as follows. With no evidence, the probability that John is the rapist is very small, say 1 in 2 million. If we get a DNA match, it suddenly rises to 0.98. But then Mary's testimony comes in. Maybe then the posterior probability of the hypothesis, as it's called, goes down to 0.48. Maybe we then get the further evidence that Mary is John's boyfriend, and then the probability rises again to 0.91. So that's the kind of thinking that you apply when you do Bayesian updating when the evidence comes in. I will skip this one. Okay, so how can I now relate these various ways of thinking about the same case? And I will from now on just focus on the argumentation approach and compare it to the Bayesian approach. And I will use one generalization that what witnesses say is usually true. In formal argumentation theory, they often call that argumentation schemes, which have critical questions, which are typical sources of doubt in a generalization. In AI terms, they can be possible exceptions to a generalization. So, for instance, is the witness sincere? Is his memory okay? And are the witness senses okay? These are the three critical questions that, for instance, David Sham uses to analyze the quality of witness testimony. So how does that work? You build an argument from the witness testimony to the conclusion. The witness says John killed Bob, therefore presumably John killed it. The critical questions allow you to build counter-arguments. For instance, the witness hates John, therefore he is not sincere when testifying about John. But the crucial aspect here is that you need evidence that this exception holds. If you don't have that, if you don't have any information about that, then the initial argument cannot be attacked and cannot be defeated. So that's the argumentation-based way of dealing with incomplete information. It allows you to feasibly draw conclusions that you may have to withdraw if you get further evidence. So in logical terms, it's a non-monotonic logic. Now, if we model the witness generalization in a Bayesian way, we would get something like this. So then the evidence is that the witness says that the hypothesis is true. So this is how you have to read the E in the formula. And then you could calculate the posterior probability of the hypothesis given the witness testimony, again in this way, by making all these estimations. But of course, in practice, that is very hard often. We don't have all these numbers, and we cannot, very often at least, reliably estimate these numbers. So what you could say is, this generalization, that witnesses usually speak the truth, says that the probability of the hypothesis given the evidence is usually high. And this doesn't only apply to this generalization, but to any generalization you could use in legal proof, like if somebody flees from the crime scene when the police arrives, they are usually involved in the crime, or bicycles offered for sale on the streets of Amsterdam for low prices are usually stolen. I mean, many evidential arguments use generalizations like that, and one way to interpret them is as well. They say that the conditional probability of their conclusion given the premises is usually high. It's not a new idea at all. I mean, if you look at non-monotonic logic, you can see more sophisticated statistical or probabilistic interpretations of generalizations, of defaults, as they are called. But this suffices to make my point. And what is that point? Well, one way to reason in legal proof is to use these generalizations and not worry about what they mean if you unpack them in terms of Bayes' theorem. You could do that in principle, but you can also say, well, these are the generalizations that I know based on my common sense, or maybe based on expert testimony, maybe based on experience, and I simply use them in the argumentation-based way. It's not against probability theory. The way you apply them is basically the statistical syllogism, as philosophers sometimes call it. It's not logical deduction because they can have exceptions. So if there is evidence for these exceptions, you can build counter-arguments against these arguments. So it's still defeasible reasoning. It captures the uncertainty that is inherent in legal proof. But you don't have to model that in an explicitly Bayesian way. But then the question, of course, is when should judges in my country or juries in the States reason which way? What kind of thinking should they adopt in the case? At this point, I came across an interesting article by Paul Thagard, cognitive scientist and philosopher, about a dual pathway model of evaluating testimony. And with testimony, he means any source of information. It can be anything, traces, for instance, documents. And he says, normally people take the default pathway. They simply believe the evidence, the content of the testimony, unless there is something special, and then they shift to a reflective pathway where they suddenly think about, well, what is the best way to explain this testimony? He then doesn't model that in a Bayesian way because he is one of these strong anti-Bayesians. He instead models it in his coherentist approach to explanatory coherence, but that's a different story. But one thing he doesn't explain in his paper is what triggers the shift from the default pathway to the reflective pathway. And I think this is a very interesting question to talk about in legal proof. I have no answers to that, I'm afraid. It's just a suggestion for research. But I think this is interesting, that thinking about legal evidence can take place at various levels of abstraction, a shallow level where you reason with default generalizations in a defeasible way, but at some point you might have to zoom in, shift maybe to a detailed Bayesian modeling, or maybe a narrative modeling in a story-based approach. And I think it would be interesting to investigate these processes, how these shifts occur and when they should occur. Okay, I would like to end with this quote by two British forensic Bayesians who have been strongly advocating the Bayesian approach in court, Norman Fenton and Martin Neal, who wrote in one paper a few years ago, unfortunately, while simple examples of Bayes' theorem are easy for statisticians and for mathematically literate people to understand, the same is not true of the general public. Indeed, we believe that for many people, and this includes from our own experience, highly intelligent barristers, judges, and surgeons, any attempt to use Bayes' theorem to explain a fallacy is completely hopeless. They simply switch off at the sight of a formula and fail to follow the argument. Well, then you would expect that they reject the use of Bayesian methods in court, but no. On the contrary, they say, you just have to believe us. You just have to believe what we experts tell you. Our proposal is that there should be no more need to present Bayesian arguments from first principles. Then there should be a need to explain the underlying circuit calculations that take place in a calculator for the division function. Of course, none of you is ever questioning the functioning of your calculator, and in the same way, judges and juries should simply believe what the experts tell them in Bayesian ways. Well, I'm glad you were all laughing, because I don't believe in this either. So to make the bridge with our current research project, I said Bart and I and our PhD students are taking a different route. Charlotte Fleck in Groningen is trying to see how Bayesian networks, when offered in court, could be explained to the fact finder in terms of stories, scenarios, and Stuart Timmer is trying to do the same by trying to extract arguments from Bayesian networks and presenting these arguments and also counter-arguments to the fact finders in an attempt to make these Bayesian networks more intelligible and more understandable. By no means claim that we have found a solution already. I think it's a difficult research problem, but for that reason it's also a very challenging research problem, which is worth studying. And I think I stop here. Thank you for your attention.
Thank you, Henry Parker. Next speaker is Sarah Lowski. Sarah Lowski is professor of law at the University of California at Irvine. She specializes in tax law and the relationship between probability and tax law. But more recently, she got very much interested in philosophy, and she is also doing her doctoral studies in philosophy, and she's working on defeasible reasoning. That's why we thought she would be an excellent commentator for Henry Parker. One article I should like to mention is Modeling Tax Law Uncertainty, which came out at Stanford Law Review in 2013. Please welcome Professor Sarah Lowski.
There we go. That's what I would like to do. Sorry about this. All right. Okay. Okay, excellent. All right, so I'll begin by distilling what I take to be some of the main points of the argument that we just heard, and then I'll focus on the question that I think is the very interesting question. Yes, and then I'll focus on the question that I think is, that'll be a little bit too like rock and roll for me. Right? I'll finish my talk and I'll drop the mic. I'll be like, Lowski out. Okay, no, that's not going to happen. Never mind. All right. And then I'll end by focusing on, I think, the last the question that you raised, I think, is a really interesting and difficult question, which is, how do we know when to use the sort of quick and dirty reasoning as opposed to the sort of more in-depth reasoning? I mean, I don't have an answer either, but I just had some thoughts about that. And I'm also going to ask something I've been wondering as I listen to all these quite varied and wonderful talks, which is how much people here are really disagreeing as opposed to just talking about different things. And I think this paper that we just heard brings up some of those points. So first, just a quick summary. We heard the distinction between direct and indirect probabilistic reasoning. Direct probabilistic reasoning goes evidence to hypothesis. So if E, then usually H, and we have our double line, presumably H, as opposed to indirect, hypothesis to evidence and back to hypothesis. And it's maybe statistical reasoning, story-based reasoning. And we heard the description of different models of legal proof, statistical, story-based, and argument-based. Each is comparing something. Statistical argument compares, well, how well does this hypothesis explain the evidence? How well does that hypothesis explain the evidence? Indirect reasoning. Story-based, how well do these different stories explain? Indirect reasoning. And argument-based, well, this argument compared this argument to this counter-argument. And then that's direct reasoning. So I think a key move here is the claim that default logic accords with the axioms of probability. Why do we see that? Well, if this is what the reasoning looks like, if E, then usually H, and then we get presumably H. But hey, we can translate that in a way that it totally fits with probability. We'll just say this. If the probability of the evidence is 1, and the probability of the hypothesis given the evidence is high, then we can deductively conclude that the probability of the hypothesis is high. And the idea here, of course, is that if the probability of evidence is 1, we can associate the probability of the hypothesis given the evidence with the probability of the hypothesis. And notice that we had to know the probability of the evidence here before we could come to our conclusion. So the probability of the evidence is the prior probability, right? So this is a little twist or something. All right. So whenever folks can agree that the probability of the hypothesis given the evidence is high, well, maybe whenever they can agree, we're going to have to bracket that. In some situation, when we can somehow feel comfortable about that, we can engage in this kind of reasoning, this quick and dirty reasoning or shallow reasoning, none of which is to judge that kind of reasoning. Those aren't my terms. Those can be good. Sometimes quick and dirty is good or shallow is good. I don't want to sound judgy on that, but we can engage in that. So that's the basic idea. That's the quick and dirty version of the longer talk that we just heard. And now I want to ask some questions. So first, a very small point. There's the shallow reasoning, there's the deep reasoning. Presumably there's stuff in the middle as well, right? So we can we get this, and then we can decompose that into the longer version. Maybe there's some scenario where everybody agrees on the probability of the evidence, so we don't have to go all the way to the sort of uglier, larger, cashed out Bayes theorem. Maybe that's all that's going on, partly what's going on in the probabilistic version of direct reasoning. So maybe sometimes we can get something that's maybe in the middle, a little more practical than doing the whole blown up thing, but not quite as quick as the quick and dirty reasoning. So that's just a sort of smaller point that I wondered about. My larger point, I think, just relates to this question that we finished with, which is maybe that you're providing us with a way to see that the statistical or Bayesian reasoning and default logic approach might seem to be at odds, but really they're two stages of the same type of reasoning. So maybe this is one way to characterize it. First, you arrive at a view about the probability of the hypothesis given the evidence. Then once you have that, proceed to a view about the probability of the hypothesis. The first part, if the probability of the hypothesis given the evidence is high, and the probability of the evidence is 1, then it's rational to go on and get our view about the probability of the hypothesis. And in terms of, let me just make a quick comment about the probability of the evidence. The evidence here, and I think this is important, so let's say a witness comes up and testifies the bus was red or whatever. The evidence is not the bus was red. The evidence for these purposes is the witness testified that the bus was red. So that's kind of sort of, that makes more, a little more, that's why I think you can say the probability of the evidence is 1, because the evidence isn't the bus was red. The evidence is the witness testified that the bus was red. So at any rate. All right, so if we can get it to a view about the probability of the hypothesis given the evidence, we can take the second step. But if we can't get to a view about the first thing that everyone, well, again, I'm not sure, maybe it's that it's correct or that everyone agrees on it or something along those lines, then we have to go into the deeper, more cashed out approach, the Bayesian approach. And if you care about the axioms of probability, which I think it's certainly a view that you might not particularly care whether people accord with those axioms, but I don't take that to be your position. So if you do, or maybe it is, but I didn't take that to be your position, if you do care about whether people accord with the axioms of probability, you could have views about whether people are wrong about the first point, right? If you're thinking about things probabilistically, you could think, oh, well, everyone thinks such and such, but they're wrong. That's a coherent thing to say if you have views about whether, if you are buying into the axioms of probability. So maybe the problem, to the extent there's any disagreement, or not to the extent that there's a disagreement, maybe the problem is in the first step. Once we get to the second step, once we've gotten to a view about the probability of the hypothesis given the evidence, we're okay, we can proceed, and it's consistent with the axioms of probability as he's shown us. Default logic can be consistent, but it's that last step that's the default logic part, and the first step can be the tricky part. So maybe there's not a disagreement between like Fenton and Neal and you. So about some things there are, like there maybe there's a disagreement about whether everyone should just listen to them and believe them like they're a calculator. But maybe there's not a disagreement about when Bayesian modeling is called for. Maybe there is, but maybe there isn't, because what you say is we're going to capture the situation where there are fallacies, some kind of exception to the rule, and they seem to be looking at the situation in which there are fallacies, right? So you say, we're going to go with the second approach, the default logic approach, unless there's some reason not to, unless there's some reason to go to the first part. They seem very fixed on the first part. Look, here's all these situations where these fallacies arrive. Whatever shall we do about it? And you say, okay, let's say we're not in one of these situations where the fallacy arises, then we can have this sort of smooth sailing going forward. So let's just look at an example that everyone's familiar with to get a sense of how this might come up, right? Everyone's familiar with the blue cab or the red cab. The witness testifies a blue cab hit the pedestrian. The witness has an 80% chance of correctly identifying the color, and 85% of the cabs in the city are red. Classic base rate situation. So it's not that there's some kind of undercutter with regard to the witness here or something like that. It's not that the witness has a bad memory or his senses didn't function properly. The problem comes, which I took to be the questions that you want to ask to see if we should not follow not go through the inference, right? If the problem is that people are going to take this information and maybe not be very good at reasoning with it, right? So it's not that we throw this out and we say, well, the witness said, the second part, the witness has an 80% chance of correctly identifying the color. That's the part that gives us some comfort that it's not that their senses are impaired or something like that. But the problem is exactly that people are going to take this information and sort of maybe not know exactly what to do with it. So the question, I guess, is we want to be able to ask some question that will catch these situations, right? We want to be able to come up with some question we can ask that's like the questions, are the senses impaired or something, that will let us catch these situations and know that we need to somehow trigger the more difficult kind of reasoning. And I was trying to think about what would that question be, right? So it's not, is this a situation in which the base rate fallacy has occurred? Well, and that means, what is that going to mean? That's going to mean we do it for everything, and that's not what we want. Maybe it's, is this a situation in which the base rate could be relevant? But if we're going to go down that path, then we have to make a list of all these fallacies that these cognitive scientists have, and there's like these long lists of fallacies that they've identified, and any time that we're in a situation in which one might be triggered, then maybe we have to go down that path, but then I think we're getting off, we're getting into the situation where the exceptions are sort of swallowing up the rule now. So, I don't know, I worried a little bit that the deeper reasoning might be triggered so often that it would actually go back to making things implausible. I also worry a little bit that, well, no, people can always misuse things. Never mind, I don't worry about that. I mean, I do worry about it, but not for here. All right. So those were just some sort of thoughts I had about the harder question that I don't really know how to answer it, but it was just sort of, I think thinking about the question of when you have to switch into the harder reasoning is a difficult question. So I just want to close by pointing out, I think, a few distinctions that are sort of moving around here, because as I listen to these various talks, it's not clear to me, although people seem to be disagreeing at various times, it's actually not clear to me that people are actually disagreeing or just talking about different things. That was a big thing that I took from your talk and also your paper, was that people who seem to be disagreeing might actually just be talking about different stages of reasoning. So that was the first one. So which part of the reasoning process is being described? Is it the first part where you arrive at a particular probability, or is the second part where you do something with that probability? So maybe that's one distinction. It wasn't clear to me the extent to which you were, for example, disagreeing with the, because it certainly would be possible to disagree with, in a deeper way with sort of the Bayesian approach, but I didn't see that as happening. You were saying, look, sometimes we can just skip this first part, maybe, but that's different than disagreeing. Some people seem to be talking about modeling things, and other people seem to be talking here about trying to describe things as accurately as possible. That's not exactly disagreeing if one person's talking about modeling and the other person is just trying to describe what's going on as accurately as possible. And the other thing is that some people, and Bill mentioned this in his talk, some people are being descriptive, trying to think about how people do reason, and some people are being normative and trying to talk about how people should reason. So in some ways, I feel like as I hear all these things described, I'm hearing actually a tremendous amount of agreement, some disagreement, but a lot of agreement, but a lot of people describing a lot of different things. And so that was the main thing I think I took away from this paper, was it seemed to me that you were saying the default reasoning in Bayesianism isn't at odds, it's just doing different, it may be doing, it's sometimes simply addressing different parts of reasoning.
Thank you, Sarah. Henry, do you want to say a few words?
So thank you for already beginning to answer the question I just asked at the end of my talk. Some very interesting thoughts. Let's see if I can say something more. So one thing about the blue and red bus or cab example is, I mean, if you have such a simple example with such clear numbers and supposedly no opportunity to find further evidence, then, well, go ahead and use Bayes. I mean, what else do you need? But of course, in reality, examples are almost never as simple as that. And especially in more realistic cases, I think that it's often very hard to use a fully Bayesian way of thinking, especially if, well, it may be appropriate with certain types of scientific evidence like DNA, but that is often only part of the evidence that is available. And even if you can, with high likelihood, say this DNA is of that person, then the further inferences you want to draw from that are much more shaky. I mean, does that mean he was at the crime scene, or did the DNA come there in some other way? If he was at the crime scene, was he the one who did it, or was it maybe somebody else? Yeah, so clear Bayesian thinking is only applicable, I think, at best at some aspects of a case. And the big challenge is to combine Bayesian thinking about certain parts of the evidence in an overall picture of the case. And I don't believe that Bayesian thinking is a good overall model of thinking about evidence in cases. And there the other things come in, like argumentation and scenario-based thinking. Yeah, so let's leave it at that, and yeah.
Thanks. Yeah, first of all, I think that descriptive versus normative is a spot-on remark. I think that's really good, and I think that is something that people talk about differently. Secondly, in terms of having complex systems and using Bayesian reasoning within those, I think that the current state at which we're in, there's cars that are driving autonomously currently, predominantly based on Bayesian reasoning. And so I think that people tend to underestimate what can be done with sufficiently large Bayesian nets. And so I think that's something to take into account. But then finally, the last remark that I wanted to make, and I guess this is more of the question, is that you showed the slide with these two guys that mentioned that statisticians should just be trusted at face value. And you said, I remember you saying that you kind of disagreed with that. But I think that when it comes to expert witnesses, that's usually the case what we do. Jurors don't have all of the same knowledge about something to make an expert judgment. And so they're relying on an expert witness to explain it to them and then take their opinion kind of as fact. So do you think a statistician could have a role as an expert witness providing evidence that should be taken at that face value?
Okay, first about the Google car, and more generally, the success of Bayes, that's learning, that's machine learning. That's not the same as reasoning, although it's not completely separate. I mean, I know that Bayesian learning has been extremely successful in the last decade in AI, but the point in the legal cases, of course, usually we don't have the data to learn our models from. Maybe we have data to learn probabilities for some specific types of evidence, like DNA. But you cannot learn a full model of a criminal case from data in general, except maybe in very special cases. So the success of Bayesian methods in machine learning, I don't think carry over to models of legal proof in general. So what was your second point again? Oh yeah. Of course, I'm from a country where we don't have juries, but judges. That may make things a bit different. But I mean, if you look at cases where statistics has been abused in court, I would not trust any statistical expert in court face value. I mean, there are so many. I mean, in the Lucia Debate case, I don't know if you know it. It's similar to the Sally Clark case in the UK. There were different statisticians who had completely different opinions about the interpretation of the statistical material, how it was gathered, which assumptions were made in the statistical models. No, I would never trust a statistical expert just like that. And I don't think judges, at least, should do that.
This may be too complicated, and we can talk about it later, but I've always wanted to ask you this. I think you know my view is that the evidence suggests that juridical proof is basically relative plausibility that sits atop inference, a form of inference to the best explanation. Now, I think you would lump that into the story model. Mm-hmm. I have never been able to understand the distinction you all in Europe are drawing between argumentative schemes and the story model. If you allow argumentative schemes, number one, not require that evidence support the argument and that arguments be defeasible, it looks to me like you have the same thing we're talking about. And I've never understood this distinction.
Well, today I made an attempt to explain this distinction in terms of the different directions of reasoning between the evidence and and your hypotheses. So in the usual way in which you apply the argumentation-based approach is you start from the evidence and you try to presumptively conclude things from that with the help of these argument schemes or generalizations. While in inference to the best explanation, you reason the other way around. You try to see how hypotheses explain the evidence.
But you don't reason the other way around. You reason any way that it seems like it works. So if a person wants to make a claim that in this context you have this story and here's strong evidence of this part of the hypothesis, that becomes part of the story that that person is presenting. So that's why I say maybe this is more complicated a discussion than to have right now, but you seem to be taking these simplistic models of inference to the best explanation, and I think it's much more complicated than that. There's nothing that limits juridical proof in the United States, for example, to simply asking the question, what's the probability of the evidence given the hypothesis? I'm not making that claim. But in that claim, once you answer that question, you also see that the evidence does support the hypothesis. I mean, it's implicit in that. And thus,
of course, I said
you get to the overlap between argumentation, what you are referring to as argumentation schemes, and story models.
So two replies to that. First, I also said in indirect reasoning, once you have reasoned from the hypotheses to the evidence, you make a step back, because in the end you are always interested in what is the hypothesis you can adopt. So in that sense, I agree with you. Second part of my answer is, well, Floris Becks, you know him, I hope, has tried to combine the argumentative and the other approach into a single model that hopefully comes closer to your favorite model.
I was the reviewer on his book, actually.
Okay.
So yeah, I
it was
know
you.
it pretty well.
So I actually think that the analogy that Sarah made is useful to this. So in probabilistic reasoning, sort of two of the main styles of probabilistic reasoning are generative reasoning, where you model essentially here what's the probability of seeing the evidence under certain hypotheses, and then you use Bayesian inversion. But there's also another style of statistical reasoning, which is discriminative reasoning, where you directly train a model, and of course the question is where does the training data come from, but you directly train a model where you go from evidence to hypothesis, and you come up with a probability conclusion. And I wonder if this issue of the kind of story-based versus the explanation-based, if perhaps you could sort of have a probabilistic versions of both, and if that might shed some light on it. To me, it seems like the big issue with the Bayesian reasoning is the normalization constant. So it can be relatively easy to talk about what's the probability of seeing the evidence if somebody's guilty. The other piece, what's the probability of seeing the evidence under every other possible interpretation of the world, that seems extraordinarily difficult to get a handle on, and I think that may in the end be the kind of fatal problem with anything more than very micro-level applications of Bayesian reasoning. So I'd be interested if you think there might be some illumination cast by looking at two different probabilistic ones and two different symbolic ones.
Maybe, but then I'm not enough of an expert in these probabilistic models to really comment on that. But I sympathize with you that on the last point, that this is also a problem with Bayesian approaches, yes.
Further questions or remarks?
Do you think that Peirce's abduction could be considered as a fourth model of reasoning here, or do you think it falls under one of the three?
Well, Peirce's abduction is, of course, an early version of, I would say, the story-based approach, which is inherently inference to the best explanation, which is an abductive kind of reasoning, so yeah. But nowadays we have more sophisticated models of abduction, of course, in logic, philosophy of science, and AI, so. But it goes back to Peirce, yes.
I'm sorry, this is a picky point, but I can't stand it. I'm going to have to say it. Abduction and inference to the best explanation are not the same thing. It's very clear in Peirce that he thinks of abduction as the first stage of scientific work, not the last stage, which is what inference to the best explanation looks like. And as far as I can tell, the scholarly attribution of this idea to Peirce is baseless.
Okay, I accept your point, of course, yes.
Sorry, that's a very different point.
Oh, no problem.
But maybe that's a nice point to end with, or is there another question? Thanks again.